The cases started in January 1997, which is the appellant start to developing its portions of land for industrial project. However, the land administrator notified that their piece of land is compulsory to be acquired for the project, for the highway project, for the following year, which is in April 1998. Okay, the land administrator give award to the appellants this amount of money that include the value of the market value of land, and also the amount that the appellant suffer for the money that they spend for the piling and the building and the construction, for the preparing construction site, and also advertisement and marketing. And the land administrator is like they rejected the appellant's other claim, which include the business profits and so on. So this is the beginning of the cases where the appellants start to file a first appeal to the High Court. The appellant was the registered proprietor of a piece of land known as CT 14408, lot number 1883 and 184, Mukit Semenyih district of Hulu, Langat, Selangor. The appellant started the development project that comprised 1.5-story terrace, 2.5-story semi-detached, and 3.5-story factory lot that totaling 128 units with a 3 piece of vacant land to be sold, known as Kajang 181. This shown that the land was subject to be acquired under the Act in the purpose of constructing the Kajang and Seremban Highway. However, the notice from the Land Administrator Hulu Langat through Form D and E received by the appellant after the construction has been started. The award given to the Semenyih Jaya Berhad by the Land Administrator and the High Court include the following item. The first one is the market value of the land is 176,27400, and 2, the constitutional loss at 3,234,881.75 resulting from the project termination, such as piling and building work. And the last one is severance and injury affection at 1160020. The rest of objection have been made through the Form N requesting to the land administrator to refer the matter to the Section 38 of the Act. The objection also contended the land administrator action that failed to consider the other claim of the appellants that should include the loss of the profit, costs and expenses that appellant faced since they already started the construction. The decisions of the High Court about the land reference with the two assessors from the government and private side to determine the appropriate amount of compensation that should be payable to the appellants. The High Court agreed to the valuation that entitle appellant to receive the compensation for injuries and severance in the sum of 1160020. The High Court also notified that the appellants that their reward they claim does not have risen due to the respect of the assessor under Section 40 because of the consequences of the failures of the High Court to consider the claim from on behalf of the appellants. The appellants once again appeal to the Court of Appeal against the Court of High Court. The other claim amount is around 18.2 million. The appellant submitted the fact to the High Court, and the High Court failed to take it opinion of assessor and recorded and pass it to the judges. The appellant said that they have right to appeal against the award made by the land administrator. Section 42 of the Land Acquisition Act has a provision for assessor to assist the judge on the questions of the compensation before 1984, while the assessor were the important in advising the court. Only the judge had the authority to rule on the problem arising from the land reform procedure, as well as the amount of compensation to be paid in the relation to the property acquired. As you can see in the diagram beside me, it have already stated the issue that been divided into 4 different kind of part, which is constitutional issue, provision limiting appeal under the Act, claim for loss of profit, and application of the amending Act in